Well, I have a title for this talk, Decentralizing Cap and Trade, ? I think the jury may still be out, at least in some dimensions, but it's certainly a question worth exploring. I think this title might be very provocative in Washington, perhaps a little less so here. But I do think that, as we know from the press, a cap and trade program is likely to be a very important centerpiece of federal climate change legislation. And I think that a cap and trade program is important to the states as well as to the federal government. Of course, land use is important to the states and building codes, and I take that as a given, but I want to talk today about why a cap and trade program and its operation are also important for the states. And I think when we're considering the design parameters for a market like a cap and trade program, we need to be careful not to glorify the market as a market, to think that all that matters is market efficiency and the effectiveness of the market as a market, but to recognize that the operation of a cap and trade program that's likely to affect our industrial economy has all the same complex political, economic, and environmental implications as any other environmental regulatory program. So today what I'd like to do is to go over a lot of the state's environmental and economic interests in controlling a cap and trade program, to talk a little bit about something that's been mentioned earlier, which is what would it take in federal legislation for a state to have the power to realize those interests? And then to also acknowledge and address the impact of state programs on a national program, because it is a two-way street. All right, so first, there we go. So what I first want to do before I get into that is to just talk a little bit about what I might mean by decentralization, just to get a sense of what the parameters are here. First of all, I'm not suggesting, I don't think any of the states are suggesting that we would have a fully decentralized program where every state had its own cap and trade program. So it's really a question of what kinds of options might be left to the states. And I think there are a number of possible structures. These may be possibly politically feasible. There may be others in addition. One would be a light state role. That would be just essentially a savings clause that allows states to set standards and emission goals that might differ from the federal. Another is what I call the medium state role, which would be the same, but also allows states explicitly to place some controls on trading where that was designed to accomplish some of the state's particular ends. And then thirdly, the heavier state role, which would be to do all of the above, but also to have some control over allowance distribution. All right, so let me go into a couple of the other basic parameters that I think any decentralized program even would have. Again, I'm assuming that most of the states do want to engage in at least regional, if not national trading. So no one wants to just issue their own allowances and trade internally. I'm assuming that whatever federal legislation there is would provide a federal floor, so we're not decentralizing to allow states to do less, it's only decentralizing to allow them to do more. And I'm also assuming, although perhaps this is rash, that most would agree that nationally uniform reporting and measurement requirements were important so that a currency would be, we would know what the currency was in this context. So I'm assuming all of that. What I want to now turn to are what are some of the state interests and why might they want to have a role in the design and operation of a cap and trade program. And the first is one that's been discussed a fair amount this morning already, and that is achieving stringent greenhouse gas reduction goals. There's already been a fair amount of talk about the fear that the federal cap, both short and long term, will be not stringent enough, that in any given year we may have over-allocated allowances, and so states may want to be more demanding. Now, I think in theory, at least, a savings clause should be enough to protect a state's ability to set a more stringent goal. But I think, as was discussed this morning, that if you have national trading, that could essentially erase the effectiveness of the state's goal because any allowances, any additional reductions achieved by the state would just free up allowances elsewhere. So you do need to have some kind of a system for retiring allowances to make a state's interest in a more stringent greenhouse gas goal viable. All right, so that's one issue. Another concern regarding, again, achieving greenhouse gas reduction goals is ultimately the use of international allowances and offsets. I think this raises very important political issues. Every time you allow the use of an offset, whether it's an international offset from a developing country or an offset from biological sequestration, you're essentially telling the regulated sector that they can essentially buy the right to continue polluting and have the reductions occur outside of that sector. So you're not getting reductions occurring in the regulated sectors themselves. And if it's an international trade, then you're not even having the reductions occur in the United States. You're essentially saying we're going to, at this point in time, pay other countries to do the reductions for us. And I think that's a very politically sensitive question because it impacts how much our commitment to reduce greenhouse gases is being accomplished by looking at our own operations versus simply paying for others to take care of it. So I think it's conceivable that the federal program will allow more offset use than some states may choose. Some states may say, we want to create more incentives for internal change, and if we allow a lot of offset use, that's not going to happen. So I think the states may have a different judgment about how much to allow offset use. They may also have concerns about the legitimacy of offsets, whether it's international trading offsets or biological sequestration offsets, and they may not feel like the verification mechanisms being established at the international level or the issues that can't be solved about verifying biological sequestration. They may want to choose more limits on those kinds of offsets than the federal program. So I think there may be a state interest in having a different permissible allowable amount of offset use. Here, I'm not sure a savings clause would suffice to preserve a state's power to impose different limits on their ability to use offsets that might be available in the national market. I don't actually have a final answer on the question, but it's possible that the beauty of the free trade, unfettered trading system, that this could be seen as a violation of it. There are also some issues about whether a state's not using offsets just frees them up for other states to use and how effective a state's efforts to limit it would be. But again, that would depend in part on the extent of the federal limits. So offset use, I think, international trading offset use is another area of key state interest. Also, co-pollutant impacts, right? So, of course, greenhouse gases don't have local impacts, but every time you combust, you end up with not only greenhouse gases, but much more harmful co-pollutants. And since every trade, therefore, has co-pollutant impacts, certain states, like California, may want to place some controls on trading in order to address the co-pollutant impacts and also to achieve some of the co-pollutant reduction opportunities that a greenhouse gas trading may offer. So I think some states, and again, it's not clear what California is going to do. California has legislation that explicitly includes achieving environmental co-benefits as one of its objectives. It's not clear exactly how that will play out in California's own cap-and-trade program, but at least the issue is whether California would have the option to impose limits on trading that would allow California to achieve these co-pollutant benefits. Another environmental concern is the monitoring and enforcement. Every time you have a greenhouse gas trade, you're also having the co-pollutants that are going with it. And if you have a state system for regulating co-pollutants and a federal system for monitoring greenhouse gases, you need to make sure you're at least checking very carefully to make sure the trades aren't having unexpected or unintended consequences on the co-pollutants. I think a savings clause in federal legislation would not be enough to preserve the state's ability to impose limits based on co-pollutant concerns. Again, others have mentioned the case law that has shown how easily the courts will find implied preemption. And here, I think you would have impacts on the federal goals of efficiency. You would be adding some transaction costs, and I could see a court viewing that as in conflict with the federal program. So I think you would need to have explicit authority in federal legislation if you wanted to allow this. Okay, so those are a couple of kinds of environmental concerns. One is, again, achieving the greenhouse goals themselves, and the other is the co-pollutants. There are also economic concerns, and I think there are a lot of political and economic issues associated with allowance distributions. There are a lot of key questions that have to be resolved in the design of a cap-and-trade program with enormous political and economic stakes, and the state's judgment may differ from the federal judgment in a lot of these areas. So, for example, with regard to program coverage, what sectors to include? How large or how small of facilities to include. The state's judgments may differ from the federal on this matter.